I would put it into every transactional document and say, this transaction, if it is subject to FinCEN reporting, will obligate disclosures by buyer and seller. Buyer and seller hereby agree to make said disclosures.
Hello, everyone. Welcome to Keys to Real Estate, the podcast where we explore what's really happening behind the headlines, across transactions, and inside the systems shaping the real estate industry. I'm your host, Mary Schuster, and today we're tackling a major regulatory shift that every practitioner, not only in the title and settlement agents, as well as attorneys who practice in real estate, but also estate planners, financial planners, and even trust officers and realtors, everyone needs to understand before December 1st. Now, the Financial Crimes Enforcement Network, or FinCEN, has issued a sweeping new rule requiring the reporting of certain residential real estate transfers, particularly those involving legal entities and trusts. So it's technical, yes, but it's also going to change how you do business, especially if you're involved in estate planning or in non-finance transactions. So joining me today is Ruth Dillingham, an attorney, national title professional, and one of the foremost experts on compliance and real estate law. Ruth's recent article on the FinCEN rule laid out what's required, and it's posted on our blog site, which I recommend you check out in conjunction with this episode. Ruth has pulled together a terrific overview and a great scenario matrix to help you sort out the main constructs of what the FinCEN reporting requirements will be. So take a minute to check it out. There's a link in today's show notes, or you can just visit octoberresearch.com/blog. And it's the guest post dated July 8th. So grab it, take a look at it, then come back and listen in or watch, because in this episode, we go deeper into the practical questions, the operational realities, and the who does what questions that your office needs to prepare for. So whether you're working on estate plans, handling deed transfers, or advising clients on structuring ownership, this is a conversation you can't afford to miss. So let's get right to it with the incomparable Ruth Dillingham. The presenting sponsor for this season of Keys to Real Estate is Closing Lock. Working in title, do you ever feel like you've got a target on your back? Every year, $2 trillion moves in and out of escrow accounts in the United States. Fraudsters are watching and waiting for one wrong click, one unsecured email, just one oversight. And then just like that, your client's life savings are gone. That's where Closing Lock comes in. Closing Lock provides title companies a secure, all-in-one platform to prevent fraud, protect funds, and streamline closings. Over 1 million home sales have closed safely without incident in Closing Lock. The fraudsters only have to be right once. Title companies have to be right every time. Closing Lock has your back. Visit closinglock.com today to learn more. Well, Ruth Dillingham, welcome to Keys to Real Estate.
Thank you.
Well, when you and I suit up and ride, it means something big's going on, because together we suited up and rode for RESPA reform. We had some new forms that took effect January 1st of 2010. Then we suited up and rode for a TRID go live, which was October of 2015. And now we have a new date coming up, December 1st of 2025. We have been doing this a long time. So December 1st, 2025, another big thing goes live. Let's tell the people what they need to know. FinCEN reporting. What is it?
Okay. Yeah. That is the day that the U.S. Treasury, through the FinCEN, or the Financial Crimes Enforcement Network, will be implementing their residential real estate reports rule. And it will require reporting, which we'll get into some particulars on, about certain real estate transactions to the federal government. Now, before everyone starts clutching their pearls, why are we reporting to the federal government? First and foremost, because of the USA Patriot Act, a statute that passed after the 9/11 horrible attacks, when it was realized that money could flow quite easily throughout our economy without anybody tracking it or knowing whose money it was or how it came into the country, and that the side effect of that is rampant money laundering. And so that is the effect, and that is what the USA Patriot Act is out there to do, is combat money laundering for our purposes. And we've already seen this happen with banks and mortgage companies. Nobody just walks into a bank and opens a checking account anymore. They need to know who you are. No one gets a mortgage without showing their driver's license. They need to know who you are. Well, this is much the same idea for real estate transactions. And as has been reported and verified repeatedly, real estate is prime for money laundering. It's expensive, it appreciates in value, and even though it is considered an illiquid asset, once you decide to terminate your ownership interest, you walk away with the money. So it is an excellent means by which money launderers have realized it's a good asset to use. So, what happens on December 1st? All non financed residential transactions where any of the transferees is not an individual will be reportable to FinCEN. There's no exceptions for the geographic area, the way there were with the GTOs, and there's no dollar amount. Gifts count. Things for no consideration will be included. And it's different from the Corporate Transparency Act, which for a while was going to require all beneficial owners of any sort of an entity be reported through FinCEN for the life of that entity. This is only about who acquires title. So anytime there's a transfer of title, you scrutinize it, see if it's reportable, report. But you don't have to monitor the ownership interest over time. And just to nip another one, aren't lawyers exempt from all this under our attorney-client privilege? No. Attorneys are not exempt from Bank Secrecy Act requirements, and I refer you to ABA Rule 1.6, paren B, paren 6, if you'd like to double check.
Okay, so if I'm an attorney and I hear this, is it just cash transactions then?
Well, this is cash or gifts. And
okay, so let's explore that gift category a little bit.
that's where I think a large segment of transactions who are handled probably by attorneys may not have as much information as they need to have to prepare for December 1st. I'm thinking particularly of estate planners.
Okay.
The vast majority of the transactions in an estate plan involving real estate fit or usually fit into this template. The transaction is into a trust or an entity, such as an LLC, because the idea is that there will be multiple owners. So, mom and dad own a vacation home. They want to transfer it to all the grandchildren. They don't want to figure out as individuals who's getting what share. It's easier to do it in a vehicle that allows for transferable shares, such as an LLC. Perfect ownership entity for what mom and dad want to accomplish. There's no consideration and there's no financing. It's a transaction, and probably for those who are busy doing estate planning work, I bet some of those folks put one of these on a month, maybe even more often. So thinking about that group of transactions, I'm really concerned that while land title associations, certainly the American Land Title Association, and probably the Real Property Bar within state bar associations are educating, not so sure that the trust and estates family attorneys are getting the same level of heads up. So just to underscore, it does apply to those transactions.
Okay. All right. So let's help people that haven't yet had exposure to this think about it in a different way. Like, you're my attorney. You know who I am. You know I'm not whatever that they're looking for. Steelman, if you will, for me, the side of the argument of why it should matter when I'm moving a piece of property from myself to my trust for zero consideration. Why does anybody care again?
Well, because while you're doing it as a matter of forethought to protect your children's ownership in everyone's favorite inherited vacation home, it's also a corporate entity behind which bad guys can and do hide. And FinCEN cannot leave that level of discretion up to the individual attorney or settlement agent doing the transaction. They have to have a black and white rule. That's what the black and white rule says. And if everybody's on the up and up, the report gets made and nothing ever comes of it. It's when the report gets made and one of the transferees is also someone who is already under suspicion that it underscores the reason for suspicion and can flag through a layering of these types of reports, flag someone that candidly the federal government should be sort of keeping an eye on for what are they up to.
Okay, so you mentioned title and settlement, and you mentioned real estate attorneys. So you said also estate planning attorneys,
Yep.
like trust department at banks, they do some work like this, right?
Yeah, they would need to know about the rule. Now, granted, there are some exceptions, which I'm not going to get into. Obviously, if the transferee, yes, a corporation, the transferee is the Heinz ketchup company. No, that's not that's not a reportable transaction. There are clear exceptions for publicly traded corporations and banks and government and a whole host of entities who are already under scrutiny. What they're looking for is the smaller corporation, LLC, trust that has no other reason to be looked at in terms of FinCEN.
Okay.
That's
Okay.
a
So some other
broad
financial planners are,
generalization.
yeah, it's broad. I'm just trying to catch the umbrella of who all needs to be aware of this in the big picture. Financial planners, I'm guessing we probably need realtors to know about this
Yes.
because they're
Now,
going to interact with that.
absolutely. Now, on what's almost the polar opposite of something like a financial planner. So you and I have discussed in the past, gee, what if I go into a financial planner, da da da. And yes, that person knows everybody in the transaction. That lawyer knows who the sellers are, their clients, knows who all the sellers' grandchildren are, their clients. There's nothing that anyone has any reason not to share the information. And probably it's all a matter of in the file here at the law firm. The other extreme is the cash sale with third parties. And that's another group of people, real estate agents, handling those transactions who are definitely going to need to be up to speed on this rule and really thinking about their interaction with their client, the buyer and seller. So if I had an example for a estate planning situation, my example for the cash sale, so to speak, is you have someone who owns a 3-family house in a city like the city of Boston. We've got a whole bunch of 3 families there, or Philadelphia or Baltimore, owns a under 4-family units and holds title in a trust because somebody told him, hey, you should hold title in a trust. It'll protect you in case someone slips and falls down a flight of stairs, right? So would insurance, but we won't go there. So he holds title in a trust, and he now is going to list it and sell and move on. And the real estate agent comes to him and says, holy moly, are you in luck? We've got a cash buyer. And he says, terrific. I've heard wonderful things about these cash buyers. They don't have to go through all the hoops at the bank. Wonderful. Bring it on. And then signs a purchase contract. And perhaps, as they frequently do, the contract says, maybe it says Mary Schuster, but maybe it says Mary Schuster or her nominee. Now, Mary Schuster goes and talks to her attorney who says, if you're going to buy a 3-family house, Mary, you really want to buy it in a trust because all the same reasons. So now Mary nominates the Schuster Family Trust to be the entity to take title. By doing that and paying cash, we have now triggered a FinCEN reportable event. It's 1 to 4 families, no financing, And the entity acquiring title is a trust or entity, not individual. So, may I move on to what that all triggers? Because it might be
Yes,
a
please
bit.
do.
So, now our transaction, and this is where I'm hoping real estate agents and their trade associations, importantly, their trade associations are right on top of this, are going to be faced with the settlement agent who's handling the closing saying to the transferee, "Hi, Mary, I notice you're taking title in a trust. I need to know a lot of information about that. Who's the trustee? Who are all the beneficiaries? What's their date of birth? What's their country of origin, like citizenship? If they're minors, it can be. I'm not going to get into the whole long laundry list. It's all available in a number of different ways. But all of a sudden, Mary is now telling the settlement agent everything about this trust that's taking title. The real estate agent should also be forewarning the transferor, the one who's selling. Oh, well, you hold title in a trust. Well, guess what? You also have to tell me all about your trust, the name of the trustee, the date of the trust, the beneficiaries, and on and on and on and on. So I'm not as concerned about the transferee, the buyer, you in my story, because if you've decided to take title in a trust, that was your decision. But the seller, just because he accepted the cash transaction, didn't sign up for this reporting to FinCEN status. Real estate agents are really going to have to pay attention to making that understandable to their sellers.
Well, as you're walking through that, it made me think about all of the builders and developers that I used to close that had their stuff usually an LLC, sometimes in a trust. Those builders and developers that I knew were exceedingly private people. And they'd get a new attorney on the other side that wanted to see an operating agreement. They'd be like, "You're right. You're going to have to coach some of these folks through." And then that got me thinking, well, sometimes who's at the actual just signing are just notaries. And this is sounding like some very sensitive, non-public information.
Yes.
So we have to talk about all that
Right.
sensitivity and handling and who all needs
Yes.
to know. I didn't mean to interrupt you. You
No.
got me thinking of more scenarios. Go ahead.
Yes. So just to quickly wrap up what the rule requires, in addition to information about the buyer and seller, also a full legal description of the property and the sources of funds. And again, we'll talk in a minute because I know you want to get into this about NPI, but all those bank accounts, okay? In addition, just as a final little caveat, the report has to be made within 30 days of the transaction, and there are civil and criminal penalties. So we can go into any of those as you wish, but let's talk maybe for a moment about how is all this information going to be flying around out there.
Let's talk about it.
First and foremost, all of these off-record names and dates of birth and physical addresses and all that stuff, how are you going to collect that? Well, back in the day when you and I started out, you'd pick up the phone and call somebody, but I guess no one does that anymore.
Right.
My fear, and again, I'm a fearful person about stuff like that, is someone sends a text message. "Hey, Mary, know that we've got abbreviated closing, CLSG, coming up, with an arrow up. Need your SOS-SEC num and routing and account numbers for all funds. THX Ruth." And Mary then sits down and gets her little thumbs running and texts back all that stuff. This is a terrible idea. I believe caution, and a lot of folks in this industry are very cautious, which is good. Caution will dictate, let's use a form, let's send it maybe not hyper securely, but let's make sure that it's sent from a secure email address such as R. Dillingham at DillinghamLawLLC.com rather than Ruthie Rocks at Yahoo.
Gmail.
And
that's great, except you're probably sending it to your borrower's Gmail account, and that's just as insecure.
yes, exactly. And the borrower, my fear is the borrower says, oh, I got this thing and I don't have access to my computer right now to sit down with my email account, but I got my phone. I'll just text it all to her. Anyhow, that's one whole set of the data that we should be
That's a
thinking about.
whole set of
The
problems. Yeah.
other side is all these bank accounts. So, Mary, where are you
Right.
getting the money to buy this 3-family house? Oh, well, let's see. My parents are giving me a gift out of my inheritance. So that's coming from my parents' Fidelity account. So that's in the name of, and here's all the tracking information on that. And my fiance has a separate savings account and he's going to be donating because we're going to be buying it. Well, the two of us are the beneficiaries of the trust. So, we think we're buying it joint. And then, of course, I'm doing a qualified distribution out of my 401k because I can borrow against it for acquisition as long as I pay it back with it. So we could have multiple accounts with routing numbers and names and account numbers. And we got to make sure that this stuff gets handled with the appropriate kid gloves so it doesn't fall into the wrong hands.
Well, yes, because God knows nobody's ever had fraud happen just because our trust account wiring instructions were sent around. So
Yeah.
let's just open up a roadmap to everybody's bank account and the entire transaction is what
Yep.
we're going to need to do for this. We're going to have to be very careful. All right. Who is a
Yes.
reporting person?
Well, there's a cascade of reporting people.
A
Yes.
cascade.
Yes, a cascade. FinCEN, and I honestly don't know. Do they have a sense of humor? It's something. But they must have been reading something the day they wrote this rule that indicated that you can have a phrase called if not, comma, then. So we have a cascade of mandated reporters. First is the settlement or closing agent. Now, you and I have worked in settlement and closing our whole lives. And in a cash transaction, or technically a non-financed transaction, there's probably one law firm, settlement agent, escrow company that got tagged to host the closing, so to speak. Make sure everybody brings the right documents, the right money, whatever. So that's your number one, the settlement or closing agent. If not, comma, then number two, the person who prepares the settlement statement. So even if all that happens is you're doing an accommodation settlement statement of cash in, cash out, you're second on the cascade. Number three, the person who underwrites the owner's title insurance policy. Now, for those who are listening in the title insurance world, their first question is the agent or the underwriter? And I assume you're going to bank that question for a revisit in a few minutes. The person who disperses the funds comes next. Well, what if two people are dispersing the funds? The one dispersing the largest amount of money. Next, the person who evaluates title. Well, is that the title examiner? Is that the person who prepares the commitment? Is it the person, I don't know, but it's who evaluates title. At the very bottom of the list, the person who prepares the deed or the transfer document. So if you're, again, doing an accommodation and you're just drafting a deed, you're on the list. It is interesting that they set it up with this so-called cascade. And within that cascade, they allow anyone to delegate to another one on the list, but there has to be a transaction-specific delegation document.
Okay.
Yeah.
All right. So let's say I'm in role number 2 and I know I'm going to be like if not the first, the second guy they call. Can I certify or need I certify to number 3 through 7 and even maybe 1 that I've got it? Because I
Yes.
shouldn't be sharing all around. I shouldn't say, "Hey everybody, here's all this." That would be the absolute wrong thing to do. So we could all report and all keep our nose cleans, but then you're putting the data in play, and
Right.
that's least
No,
desirable. So can I
only
say,
one
or should
entity
I
can
say
make
I
the
got it?
report. Only one entity can make
Only
the
one
report.
entity can. So somebody's got to call the ball and say, I've got this. And then I can rely on their saying that to me, or
Yes.
I'm guessing
Yes.
writing that to me.
The rule does allow for so-called reasonable reliance. So if someone says to you, I've
Okay.
got this, I think that's going to fall into that. And with this
Okay.
delegation situation, so let's say the settlement or closing agent, let's say, I'm hypothetically, let's say the settlement closing agent is really big corporate law firm, Wall Street, New York. And the last thing they want to do is be a FinCEN reporter. They're like, no, thank you. So they turn to someone further down the cascade and say, hey, person who did the title work for me, how, let's say you're going to be called person who evaluates title or person who drafts deed or whatever. How would you like to be the reporter? And that person, business, says, sure, I'll take it on. And now between those two, number one and number six or whatever, there has to be a delegation document specifically saying between the two of us, the role has been delegated to this one, and it's got to be transaction specific. But with that in hand, now number one can say, I'm all set.
Okay. So if my role in this is, I'll give this scenario. I'm the title agent, and I did the settlement at my table. So do I report? Does my title underwriter report? How does that work?
That is a very, very good question. And I think a lot of underwriters, by which, for those who may still be figuring out the jargon, by which we mean the First Americans, Fidelities, Stewarts, the Old Republics, and the regionals as well. They're the
Mhm.
ones who underwrite the title insurance. Those businesses were the ones tagged with the geographic tracking orders. They were the ones
Right.
ultimately responsible for making sure it got done. And
Mm-hmm.
again, I don't work for one of them, and I'm certainly not in on the business conversations there. But I would
Mm-hmm.
not be surprised if in the C suites, people aren't saying, dodged a bullet on this one. And it's looking to the settlement agent to be the reporter, not us, the title insurance underwriter. Although the one who does the owner's title policy is the one who's on the hook, but we don't draft the policy. Our agent does that. So we're going to make sure our agents know we're not doing it for them. Flip the page, head to the west of the Mississippi River, and you've got a lot of direct operations where those same underwriters are the ones conducting the settlements. There's going to be
Yeah.
again, I think there's going to be a lot of C-suite conversations around,
Uh-huh.
do they want to voluntarily take that on? Do they want to shuffle it off to agents where they can? Certainly, again, I don't work for one and I'm not privy to anything at all. But I think if I was senior counsel at one of the major underwriters, I'd be reaching out to FinCEN and saying, just to clarify here, if we
Mhm.
have an agency relationship, I can tell the agent, this is your headache, not mine.
Well, and I think from the reporting timeline requirement, God, it almost have to be the settlement agent, because this will be the first time, to your point, you mentioned it, the GTOs that the underwriter had reports, so they had to collect and report that from the agents. Otherwise, I start thinking about other things that agents report to the federal government, the 1099 stuff. That's
Yeah.
once a year. Some
Yeah.
states have like a quarterly data call that the agents are delivering in, but it's new to have something monthly
Yeah.
that has to be flipped that quickly. So I'm not sure how, if I were an underwriter, I would be able to even gather those
Right.
statistics from
Right.
agents that closed on my paper less than 30 days ago.
Right. And
Because
what
for
if,
your agent, you'd have to sort out whose paper is it on, because you can't give them information that isn't pertaining to a file that they were the underwriter for.
and let's
Yeah.
not forget, many cash transactions don't involve an owner's title insurance policy at all.
Oh, right.
The buyer and the
Yeah, there's that.
seller, I mean, let's take the situation of the second floor tenant is now buying the 3-family house from the landlord. They're not going to go out and get an owner's title policy. They trust the guy. Yeah, I've lived here all my life. Yeah, you lived here all your life. We remember where it was built, blah, 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 blah. Here's your money. Here's your deed. Good speed. And so if there's no owner's title insurance at all, then clearly, whether it's agent or underwriter status, you step away and it goes back to settlement agent or escrow company.
All right. So, and I agree with you. I think traditional brick and mortar title settlement operations those workflow maps are not drawn out yet, but I think it's going to be easier for them to, between now and December 1st, get into the flow. I am concerned with you that some of these, to your point, the estate planning folks, the trust departments, trust family law folks aren't just going to know. I'm going to put a set of questions about them if I can, because I'm concerned about them. Are they going to need to change like their engagement letters or their client intake form? If I said, Ruth, I'm coming to you to do my will and my trust, and I want to talk about stuff, do you need me to acknowledge that at some point, or how are you going to change how you work with me, I guess, is the larger question.
I do think everyone would be very well advised to make sure people know up front that what we do is going to be reportable if it falls into the following categories. So there are two places that I see that happening. Yes, to your point, the engagement letter, or certainly the first client intake interview, where there's an exchange of what I expect from you, what you expect from me type of documentation. Mm-hmm. In the law firm category, the rules of professional responsibility as promulgated by your state are going to set up what those look like. Certainly at a well-run title and escrow company where you've got a smart business manager, whether for the state or the region, there's some expectations set. As you and I remember pre-TRID, people would sort of walk into a small direct operation of a major underwriter in a strip mall in between a pizza parlor and a dry cleaner and say, I need a deed. Yeah, right. Hand over the deed into them and come back tomorrow. We'll give you a deed out from you. That type of relaxed attitude clearly needs to tighten up. The other place, and I've seen some really positive movement on this, and I will give kudos to the American Land Title Association for spearheading it, is alerting real estate agents to putting language in the purchase and sale agreements to say, this transaction, I'd put it in every deal, because you can have something that's going to be financed and go to an individual. By the time you get to the closing table, lost the financing and it's into a trust. So I would put it into every transactional document and say, this transaction, if it is subject to FinCEN reporting, will obligate disclosures by buyer and seller. Buyer and seller hereby agree to make said disclosures, or whatever. The parallel.
Oh yeah, we need every real estate board to hear that and get that language incorporated in their board contracts. Yes. You bet.
And what I equate it to is, I'm sure you remember, and I'm not sure, you always wonder what the demographic you're talking to is. Some of you may remember before Fannie Mae required condo questionnaires, and condominium associations never revealed their budget or how many owners were past due or anything. Fannie Mae says, you know what? The quality of the management of the condominium association is every bit as important to us as the quality of our borrower. We want to know, is this a viable condominium project? Right. And condo questionnaires were born. And condo trustees balked and screamed and yelled and kicked and blah, 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 blah. And guess what? Today, every condominium association fills out the condo questionnaire every time one of their owners goes to sell. Yeah. So
yeah,
I hope it is taken in that same vein and everybody gets used to seeing it into a purchase and sale agreement. The other component, and depending again on how this all plays out, is the title insurance side of it. So
Okay.
let's say, one of our examples was the second floor tenant buys from the owner of the building and nobody gets title insurance.
Mhm.
But let's say, for instance, we have a transaction, an estate planning transaction, where mom and dad never had a title policy. And now we're going to transfer title. Mom and dad bought the beachfront house for $20,000 back in whenever. Now it's worth 1.5 million, and they're going to put it into an LLC with a bunch of the kids or grandkids. And somebody whispers, "How about getting an owner's title insurance policy on this asset?" Well, okay, now what? Or you've got an arm's length sale where the settlement agent is also a title agent and says, "I really want you, buyer, to get an owner's title policy." Or you have direct operations where, by definition, in some states, they have to issue a policy in order to be the settlement agent. And in almost every instance, they would prefer to issue a title policy rather than just be the settlement agent. So, in all of those sorts of situations, how do we rein this in? We put a condition in the commitment to insure.
Okay.
And now the title insurance owner's policy commitment says, if this transaction is subject to FinCEN reporting, all parties agree to the laundry list of all the information. Even if you have an agent who's going to be doing the reporting, a settlement agent, title agent, they want to make sure it's in there for their protection. Certainly, if you're a direct operation and a major title insurance underwriter situation, they're definitely going to want to make sure they aren't moving forward without having all the parties obligated to give them what they need in order to report. And you want to have it all before you even sit down at the closing table, because you only got 30 days.
Well, right. And so I was thinking about some of the builder developers that I talked about before. I mean, I can just imagine what their reaction would be to something like this, but making both the real estate contract, if there's a board contract, especially, or if you're the attorney that's looking over the real estate contract, to have the language in there, then double up, have it on the, well, it's not exclusively a double up, but also have it in the title commitment. That's kind of putting everybody on notice that, okay, if at some point this gets triggered, this is going to happen, so that somebody can't get their back up at the last minute and go, it's nobody's business where my money's coming from. Where's my, okay. Those are a couple good practical tips. So I want to give people some ideas to think about, some language to use as the first few times we have to introduce something to somebody, we can trip over it. And this one it's such sensitive information. So what would be like a good way to explain this requirement to somebody who's just trying to transfer their house they already own into a family trust, like they're not in a real estate deal, blah blah blah. And then I'd also like for you to give us some ideas of how to counsel somebody past some objections. Like, is it sort of a you must, or it's over, or what if I only want my attorney to have it, or some, just help us through thinking
Sure.
about some language for these scenarios.
Let me even just take a second and dwell on the word language. There's the stuff you write down, and again, I'm hearkening back to my youthful days in the closing world. We used to send out a letter to the buyer and the seller the day we found out we were going to be handling the transaction, and it said, in an envelope with a stamp that said,
And
we need you to go get homeowners insurance, or we need you to give us the account number of your bank that has your mortgage, or whatever. There is today, in some format, that same expectation level setting. And that's the place to start, is when you're reaching out to the buyer and the seller saying, however you say it, here's what I'm going to expect. Here's what you need to make sure you're getting to me. Then there's the rest of the language, so to speak, which is when someone starts pushing back and you're on the phone or you're exchanging emails. And that's a little tougher.
Yeah. Okay.
You don't control the way you do in the written word, the language. And that, I think, is going to take a lot of staff training. If it were me and my staff, I'd be doing a lot of role playing and figuring out what the escalation path is. If you've got a big enough operation, that the person on the phone with the recalcitrant seller has someone that they can refer it up to diffuse the conversation. That's always helpful, but you may be a small enough operation that that person on the phone has got to stick with it. And so then you have to decide, what is your last stance? At what point do you pull the plug? So you want to have all this data before you start any sitting down and exchanging documents and dollars. You want to make sure you've got everything in hand.
Okay. So this could throw off some deals, right?
Yes, definitely. So one of the things that I would strongly urge, and it's, if I were doing this today, which I'm not, but if I were and still had the staff I had back when I had a staff, I'd do a lot of employee training, particularly around role playing. So you've got the recalcitrant seller, you've got the grumpy buyer, you've got the real estate agent who believes this is all part of a Machiavellian plot to take over the world, whatever. And figure out what keywords folks are going to listen for, what responses they're comfortable giving, and to the extent that there can be any sort of escalation path, please consider putting one in place. Even if it's just me talking to Polly, my paralegal assistant, dog walker extraordinaire, and saying, Polly, if they get out of control, tell them, here's the boss, and I'll take the call. As anyone who's ever worked with a team doing real estate closings knows, sometimes just hearing a different voice, hearing the same words in a different cadence changes the perspective.
That's true. Well, and I'm thinking about, so I'm guessing we're seeing software providers and systems people tool things up for this, because it's always such a challenge. As a settlement agent, I always wanted to hold the least amount of MPI data that I could get away with holding. And now I'm going to have it not only about everybody at my table, and I'm responsible for that and not keeping it private and not inadvertently becoming a data broker, but I'm going to have potentially my buyer's grandchild's information or sister-in-laws, or like my universe of NPI that I'm holding just expanded in exponentially.
Yes. Yeah. And I'm not going to get into the particularities. I obviously encourage everyone to read the rule, the FAQs, and any FinCEN related information, as well as stay on top of everything that your trade association is sending you. But some of this stuff you've got to keep, some of it you don't. The stuff you do have to keep, you've got to keep in a format that can be accessed in the future. This was what we learned about floppy disks, for instance. You can no longer read a floppy disk. And to the extent that you don't need to keep it, and this has always been something I know that you went through this in your interactions with particularly attorney clients back when you had a different hat, they would photocopy everything and keep it in a file. And you would go into the office and say, why do you have a copy of their application to borrow the money that has the name and account number of every savings and checking and credit card and their social security number? Get rid of this. And the person's like, oh, but I always keep a complete file in case anyone needs it. This isn't your file to keep. This is the stuff you need to keep. Right. So I recommend everybody look at the rule. Keep only the minimal stuff that you have to keep and keep it securely.
Well, and I'm going to daisy chain together 2 or 3 questions, I hope, next. Okay, so I have all this stuff. And my first thought is, dear God, can I just get it to like a third party to handle this? Because when I think about the reporting, normally it's not, you don't report for the month of July. You have 30 days to get it reported. So I think you're going to have to kind of rolling report. You can't bundle it all up and deliver it monthly, I think, because I think you'd get out of whack there. And then what if there's an error? But I don't think I should share that with a third party provider. So, and I want to add to this complex question. What if I report inadvertently? I miskey, or I don't know that a fourth beneficiary has just been triggered or something like that. How do I do this? How do I do it safely? And what if I get it wrong?
So we'll start with the first part. which
Okay.
is, can I outsource this? So just as plenty of folks outsource the IRS reports that are triggered by any sale about a seller, you have to report to the IRS, or any other of the tasks within your closing operation, it is anticipated that FinCEN will not prohibit outsourcing. We don't know definitively yet. Certainly is something that a lot of folks are asking FinCEN to clarify. I can't rationally imagine that they'd say no. You have to physically, at the law firm of Ruth Dillingham, have only an employee who draws a paycheck from Ruth Dillingham do this. So I think outsourcing will become an option. The question is then, along with every other vendor you outsource to, what's the quality of your vendor management? And how carefully are you keeping tabs on what they're doing? And are you auditing it? And do you periodically pull a file and say, did this get done within the 30 days? And did
And
it
what's
get
their
done
disposal
correctly?
time frame? And are they claiming ownership of the data once you transmit it to them? Because I mean, some
Yeah,
you arguably you'd have a couple of people involved in a couple of people's NPI that you're sharing that are your client, and potentially many people who you have no business relationship with at all, but you have all their
right.
sensitive information. And so when I put my consumer hat on, I just go, where's my redress? I can't even find all the places my data went when I'm the third
Right.
successor trustee or whatever.
Yes. So the way it's set up at the moment, and again, this is all subject to fine tuning from FinCEN. One of the things that always worries me about sounding authoritative before the rule actually starts is that people listen to me in July and say, well, I listened to Ruth Dillingham and she and Mary sussed it out. I don't
Yeah.
need to ever educate myself on this
Right.
again.
This is not that
Ladies and
scenario.
gentlemen, please stay on top of this. This is
This is the
not the
beginning
final
of your
word.
education, not the end. Yeah, please. Good point.
So, having said that, I would recommend thinking through, okay, if I do want to outsource this, vendor management like 101, as we just discussed, and then think through who's going to bear, as to your point, who's going to bear the liability in the event of a data breach, who's going to bear the liability in the event of misreporting, who pays the penalty if there's willful non-reporting, on and on and on and on. If FinCEN sticks to its guns of that waterfall or cascade, as it were, if I'm the person who underwrites the owner's title insurance and the settlement agent, going back to my hypothetical example of the big fancy Wall Street law firm, they're not a title agent. They don't want to be the reporter. They're going to turn to the title agent. They're going to make sure there's an owner's policy, and they're going to turn to the title agent and say, here, bingo, you win. I'll do this delegation document. You're now going to do it. Because the title agent is in the cascade, they should be reporting under their FinCEN company ID, not under the law firm's FinCEN company ID, right? Because they are the delegated to reporter. The liability for misreporting sits with them. And I'm going to argue down the line, the data breach probably sits with them. However, if I am FinCEN Reports Are Us,
Right.
which sprang to life at a Thanksgiving dinner in late November by a couple of entrepreneurial folks who said, hey, we know how computers work. We can collect this data. We can run a little software program that auto populates into a website. Oh, we got this. And they start marketing themselves. They are not in the cascade. So they are going to have to report under the name and number, the ID number of whoever in the
The
cascade they're
designated
working for.
reporter.
Now, that's where my vendor management hat starts to explode, because as the one who's outsourced this, I got a lot of worries about the two bros over Thanksgiving dinner. Yeah, they're great at doing automated reporting on websites,
Right.
but are they great at handling NPI? Are they great at making sure that they do all of the stuff? And remember, I hate to throw this into it as well. Every state has their own data security protocols. And it's the state of the human being, not the state in which the transaction happens. So, where you've got six grandchildren who are now all going to be the owners of this LLC, and each of them provided their data, and each of them lives in a different state, and the three bros data reporting LLC are us
Right. Yep.
as a data breach, you've now got to report it to all six of those states.
Yep.
Vendor management on steroids. That's just all. I guess I'll leave it at that. I don't want
If
to. I
I,
don't want to beat it with
yeah,
a stick.
if
But
I were an estate attorney, I'm trying to think of best scenarios for everybody involved. And I'm not saying to get out of reporting. I'm saying to get that data in fewer hands. Would it be smart for me to advise my folks, my buyers, let's say, let's go ahead and buy as an individual. Let's put that deal to bed. Let's not involve the seller and all that. And then let's move it into your trust, knowing I would still have to report, right? If when it moves into your trust separately 2 weeks later. But at
right,
least would
yeah,
that be the best way to keep my clients' NPI from potentially being out to people who have no business?
or
And not only their clients, but their, yes, and not only my clients, but their dependents or
yeah,
beneficiaries.
all their beneficial owners, right? So
Yeah.
my sense of this is, and again, still unfolding. My
Right.
sense of this, the hard and fast rule is anytime there's a transfer that meets the criteria, it's a reportable event. And anyone who does this for a living knows full well there are people who hold title to property in a trust. They transfer it to themselves individually. They apply for a mortgage loan. They get the mortgage. And the day after the mortgage closes, they transfer title right back into the trust, which, like it or not, does it defeat the purpose of Fannie Mae saying you can't close in a trust? I don't know. But the fact of the matter is, we all know what happens.
It happens. Yeah.
I think there are a couple of things to bear in mind in your scenario.
Okay.
Number one, if the fact pattern is a heck of a lot easier to just clear through the sale, the third, not the estate planning situation, but third party strangers to each other, and the
Mm-hmm.
seller's balking, and there's just all sorts of whatever going on. And the seller says, hey, I specifically don't want to transfer to a trust. I've heard about this scuttlebutt. I don't want, you got to take title as an individual, or I'm not selling my house. Okay, you can do that. And bear in mind that the names of the individuals are now on the public record. So
Yeah.
I guess without besmirking anybody, if the buyer
Mm-hmm.
is Osama bin Laden Jr., that
Mm-hmm.
name is now in the public record. If 3 weeks later he comes into your law firm and says, I'd like to transfer a title into Allah is God Real Estate Trust or LLC, it's a reportable transaction. And now he, as the transferor, and it, as the
Yeah.
transferee, goes into FinCEN. But you didn't have to deal with the crazy seller.
Yes, deal with the crazy seller and risk it being the data at least sitting places
Right.
that are kind of outside. At least as their attorney, I've mitigated down the number of places that NPI is going.
Yep.
However, you're right. I have now not only drug them individually through title, I put them on public record. So much of the reason we might have been doing the trust or the LLC in the first place, I've just blown that. So
Yes. So, and it's a matter of how much risk avoidance, risk assumption you're comfortable taking on. I don't know if you remember, but one
right.
of the things that got a lot of attention around money laundering were law firms in New York in a 60 Minutes or a 2020 or some televised expose about the hidden camera that caught someone saying, "No, you want to keep your name out of the public record. Here's how we do it," sort of thing. So you don't want to necessarily be that person. However, if someone says, I don't mind my name being on the public record for the week or so, I got nothing to hide from anybody, but my estate planning needs are such that I need to put it into the family
Mm-hmm.
LLC. Okay,
Mm-hmm.
fine. Come back in a week and we'll have that document that entity document all drawn up, and we'll have a deed into that, and then we'll do the FinCEN reporting off of that transaction. And to underscore your point, now these people are all my clients. I'm already
Yeah.
in a relationship with them.
Right.
They know and trust that I'm not going to be the cause of a data breach. They know and trust that I'm going to keep their information secure, and it's a much more manageable set of circumstances. So
Yeah.
what
Yeah,
I
I think
recommend
for
against is advising people, let's do this individually, and then ha ha, quiet, quiet. 2 days later, let me slip you this deed in an unmarked envelope, and you just hop on down to the county recorder's office. And no, that I no, don't, let's not do that.
Yeah. I think I'd almost want them to designate for me in writing by yes, no, checkbox. Which scenario do you want to do? Here's the pros and cons to each scenario, and have them acknowledge
Yeah.
and do it that way. Because yeah, I mean, yeah, okay. So that kind of handles the kind of the estate planning attorney and maybe trust department at the bank scenario. I'm going to come back over to the closing and title world now too, because I want
Yeah.
to ask, I want to layer up some scenarios real quick if we can. And I know we've been talking a long time about this, but we're going to be having these conversations for months as professionals. So same scenario. Your Osama bin Laden Jr. one was perfect. So because you mentioned at the beginning the GTOs, the geographic targeting orders. So if it was Osama bin Laden Jr., a foreign buyer in Miami that's under a GTO, would all of these things apply? Are they all layer up, or does the FinCEN stuff kind of come over the top and act as the primary thing?
Well, the GTOs are in effect until they expire by operation of law. And the expectation is that with this coming into effect in December, those will probably lapse. Now, FinCEN hasn't said anything definitively, but
Okay.
remember, a GTO, its primary rationale for being was that Treasury identified geographic areas that were hotspots where they wanted to drill down on financial
Mm-hmm.
misbehavior. And
Mm-hmm.
so, if it turned out that their research indicated, and I think that was Miami and Manhattan were the first two that got swooped up, that these were places with a lot of cash transactions, a lot of foreign borrowers, a lot of probably foreign money coming in and being introduced into our economy here
Mm-hmm.
and quote unquote laundered, or Russian oligarchs or whatever.
Mm-hmm.
Um, that it was geographic in nature. Therefore, let's zoom in on Manhattan and Miami. But what Treasury has now learned is as soon as you play the game of whack-a-mole and knock them, they pop up somewhere else. So just because you've identified Dade County, Florida, doesn't mean that they aren't moving 3 counties north and
Right.
buying up the equivalent dollar amounts of real estate in a non-reporting county. So making it
Yeah.
national in scope makes sense. And I think probably given that reality, the GTOs will be allowed to expire, although we have not heard definitively. At least I haven't.
All right. I noticed too that you, and I appreciate this, are very careful to say non-finance, non-finance, non-finance. A lot of people that I've heard talk about this just use cash for shorthand, but there are some scenarios that are beyond cash that would be applicable to, and that leads me
Yeah.
to what if it's a cryptocurrency deal? I'm buying with crypto.
Well, I'll answer the crypto question and then we'll deal with the larger definition of non-financed.
Okay.
I think cryptocurrency is a currency.
Okay.
So and certainly those who advocate for it are saying so. So I think the fact that you're paying in bitcoins rather than American dollars or rubles, for all I know, or lira or any euros, um,
Right. Yeah.
is it's
Right.
still it's a currency based as opposed to financed transaction. That makes it reportable.
Okay.
In
Okay.
non-financed is a phrase that the rule uses very carefully because it it can be financed in many ways and still be reportable. So the type of financing that makes it not reportable is if the entity advancing the funds and securing those funds by a mortgage on the property to be acquired is a entity that has to have a Bank Secrecy Act compliant and anti-money laundering program with suspicious activity reporting obligations, to wit, banks, credit unions, savings and loan associations. Yes. However, if you are simply a very wealthy person who lends money to those who don't otherwise easily qualify for credit, and you lend money to them in your own name, to them in their own name, and you, even if you take back a mortgage on the property, you are what FinCEN has identified as a hard money lender, and you will be reported upon. And that source of funds, including what bank they came from, will be reported upon. And if you are the bank of mom and dad, and you are financing the property to be acquired by the kids, you will be reported on, because mom and dad do not have a Bank Secrecy Act compliant financial profile. So a lot of financing, or if you're borrowing against a 401k, or you're getting a home equity loan on a different piece of property that isn't this property, again, reportable transaction. It has to be a mortgage on this property from a financial institution that meets those criteria. Otherwise, it's deemed non-financed.
Okay. Let's talk about risk and enforcement. So, like, what happens if I miss reporting? I file wrong. Are there any safe harbors for people? And let's kind of talk through. Oh, what about? Oh, well, Ruth, you said December 1st, 2025. I set up my trust years ago. So is it exempt?
Yes, it's transactions that close on or after. So if you've already transferred the vacation home into the family LLC 2 years ago, we're not talking about you.
But if I set up a trust 10 years ago and go to transact through it now, it would not be exempt, right? It's when the settlement happens. Okay.
Yes, absolutely.
Thanks. Go ahead. Okay.
The other thing is if there's an error in the report. I've had a chance to look at, FinCEN has not, I will underscore, FinCEN has not yet opened up its actual website for people to kick the tires yet.
Okay.
So we don't know what it's going to feel like to file a report over the internet at U.S. Treasury. However, they did have a comment period for the types of fields that they anticipate will be at the aforementioned website, which comment period, I believe, closes Monday. And a lot of trade associations are filing their concerns, a lot of very practical things as well, such as if we've already indicated that the entity upon which we're reporting is a trust, could you gray out everything that has to do with LLCs, please? Like, we don't want to, yeah.
Right.
And one of those fields is what type of report are you making? And it looked to me, when I read through the fields, one of the options was corrected or update. Like, it looks like there's some level of honest mistake correction. I'm not sure the level to which honest mistake is going to get stretched. It was an honest mistake. I was asleep that 6 months and didn't bother to learn about this rule. Or it was an honest mistake and I misread a handwritten P to be an R or a B or something like that. One of those, I think, is a lot more of an honest mistake than the other.
Right. So what do we know about the penalties so far?
Well, penalties, which of course you'd think I'd have tattooed on my forearm, but no. There are penalties for negligence, which is
Okay.
just honest mistake, which I'm going to assume is uncorrected negligence,
All right.
which are about, I think it's about $1,300 per transaction. Maybe it's hefty, but it's not the criminal ones. Willful noncompliance. This is what worries me. This is when there's a underground economy that says, "Don't do this. I'll help you. Here's how we avoid ever getting any of right." That's willful noncompliance. That's $200,000 criminal fines and up to 5 years in jail.
Ooh, that's got some old two-page HUD language in there. We used to sign those certifications, didn't we? That sounds a little somewhat
Yeah,
familiar.
that check needs two signatures. Yes. So
Yeah.
so so clearly FinCEN is aware that there are those who don't want to get into this line of business of being
Mm-hmm.
reported upon, and they want to make it
Mm-hmm.
sure that anyone who aids and abets that knows that it's a steep set of penalties.
All right. I just wanted to visit the getting it wrong section. We don't want to live there. Let's talk more a little bit about the getting it right, because that's what everybody listening to this wants to do.
Yes.
Uh, FinCEN has estimated that the gathering and reporting efforts will take about an hour per file. Do you agree with that?
In a well trained office where every paralegal is as diligent as Mary and every boss is as compassionate as Ruth, and we do tons and tons of play acting and stress systems and make sure that if we're working with a title production, closing production software package, we are up to date on the most recent release and everybody knows how it works. I think that's probably a very realistic situation. However, the flip side of that, of course, is the attorney who only does probate type work, occasionally does an estate plan, uses the computer to once a month balances operating account checkbook on Quicken, and doesn't deal with government websites ever, and so forth. Much more time consuming. Much more time consuming. I spoke to someone who, um, by the luck of the draw, doesn't practice in one of the counties covered by a geographic tracking order, but luck would have it, got tagged with a out of county transaction, which she had to then report under the GTOs, and she said it took her
Mm-hmm.
6 hours. So you know, it's it's going to vary. I think that underscores what you and I have been saying all along, which is get ready, get your staff ready, know what you're doing, make sure you've got everyone prepared and understanding why you're doing what you're doing from the very beginning.
Well, right, agreed. Because if you have to go through a software upgrade, you have to train your staff, you have to do all this stuff. Uh, you have to, document your processes, and if you ever have a problem, oh, this is our company policy on this, and this fell outside of that,
Yep.
but we've got it covered, and all the things you have to do. I would think insurance coverage, or other things would need to be updated. Looking at this, and then so I'm just thinking about the added expenses, and then you add an hour's worth of time on top of that, depending on what employee level uh, compensation rate is for the employee you have doing this, which I would think would need to be somewhat high. I
Yeah.
can see where the margin of profitability just left that closing. It's gone. It's eaten up.
Well, they do allow you to charge for this.
Oh,
So,
okay.
as
Say more about
opposed
that.
to, yes, so back in the good old days when you and I were teaching folks how to fill out a HUD form,
Mm-hmm.
we were telling them, and you cannot charge a HUD form document prep fee.
Right.
And if you try to, you will get in trouble because it is writ large and
Yep.
enforced.
Yep.
That is not the case with this rule. And in fact, for those who have dug around in it a little bit, uh, FinCEN has even made some guesstimates based on annual statistics about who gets paid how much to do what kind of work in the American real estate processing economy, and has said, well, we think it's going to cost about this much for attorney time or this much for paralegal time or what have you. Um, so I do think certainly passing on the cost of doing this report is envisioned within the rule. I will also say, and I'm being a little bit of a snark here to quote from one of our friends in the industry,
Mm-hmm.
I don't think it should exceed the amount of the owner's title insurance premium, however.
Right. Right. Unless, when you were talking earlier, by the way, we go back to the beginning, I made a note of like, are we going to have like an equivalent to a qualified intermediary industry spring up to do this? Because that is no small feat, very worth it, what they have to do, but it's much more what they have to do and who must do it is so much more prescribed that it was easier to get there with that than it would be with this. But I am happy to know that at least the expense, it's been contemplated that the expense will be recouped through the transaction.
Yeah. Yes.
That's good.
Or some semblance thereof. I mean, let's face
Some
it.
semblance thereof.
The more,
Maybe not
the
a
more
straight
efficient-
dollar to dollar.
Yes. So if you charge a flat fee and it's a situation where at the last minute things get really mucked up, you're gonna, as you do, you're gonna lose money on it. But if you run an efficient operation, you make sure every purchase agreement has language in it obligating compliance. You make sure it's in your title insurance commitment if there's an owner's policy. You make sure you've got a form within your title and closing production system that automatically can fill out if there's going to be a designated other party doing the reporting. I mean, a lot of this can be made a lot more efficient, a lot less painful if you're using all the resources available to you. So I, hasten to add, folks should make sure they're in constant contact with their software providers and everybody. I mean, title and closing, but real estate agents, you should be paying attention to what your state or regional trade association or board, who's ever promulgating your standardized forms, those who are in other segments of the economy that dabble in real estate transfers but don't do them all the time should be listening for, what's going on in this side of the world. It will just, there's nothing worse. You and I have both done enough closings in our lives. There is nothing worse than finding a problem the day before the closing and someone is honestly and legitimately ticked off that nobody told them that this was going to happen back at the beginning when they could have
Right.
solved
Done
it.
something about
So,
it. Yeah, exactly
yeah,
right.
I mean, so if you don't tell me that who I know, I have a husband on an oil rig in Louisiana, if you don't tell me that I can't use that power of attorney to sign a note and mortgage, and it's got to be FedEx down to him, and he's got to get a day off from the rig to come in and be in front of a notary in New Orleans and get that time off reimbursed by his employer, and there's big waves in the Gulf of Mexico, and so they can't get off the rig that day, and if you had told me a month ago,
I could have
we'd be
handled it.
working
Right.
on that.
Right.
But don't tell me the night before the closing, oh, well, you and Mr. McGillicuddy will both be here tomorrow, right? Well,
Right. That's not the time. Well, and that's why we wanted to get this out to folks early so that they could start making their plans, start looking to their other trusted audiences or becoming a trusted audience for someone else. Like, again, the attorneys in the markets and the realtors and everybody needs to know on this. I'll remind everybody what I mentioned at the beginning, that Ruth has put together a wonderful kind of 101 sheet for us at our guest blog post, and we'll link that in the show notes for today. It's got I thought it was great the way you talked about what the entity is. She just went through bullet points. If this scenario, it's this. If this scenario, it's this. Because I know when we're just talking a lot about it, it can feel like it's above our head in thousands of pieces. I thought you really nailed it down. I don't think FinCEN, at least we're recording this on July 3rd, everybody. I don't think FinCEN has put out their FAQs yet, but
There's some
they
preliminary ones, but they're old. We're waiting for the
okay.
final batch that will reflect what they hear back from this most recent request for comment and what folks have learned as they've done some trainings. And
Okay.
FinCEN has been proactively reaching out to trade associations and the major underwriters and asking where their pain points are. That's the set of FAQs.
Those will be the real good ones. All right, good. And then since you're dialed in so tight with this, I know that you're working closely with some associations who are working with FinCEN. As soon as some of this gets nailed down further, would you be willing to come back and discuss more tactile implementation steps and considerations once we know them?
Sure, of course. Absolutely. I'm a firm believer that the more time you can get out in front of a group of people who are about to be impacted, particularly, I understand the podcast and the webcasts and the remote learning, and we've all had to deal with it. But in my personal opinion, nothing beats standing in front of an audience and realizing that half of them have glazed over, and you realize that the half that's glazing over are the ones you most desperately need to get it, so that you can back up and say, I may have been talking a little too quickly. Why don't we back up a slide or two and make sure we're all caught up?
Well, and I can recommend that if anyone listening has an organization that they need trained or knows of one who should be trained, Ruth knows her stuff and teaches very well in classroom settings. So, and Ruth, we have all of your information linked in the show notes. So if the people need you, they know how to get to you. Thanks for joining us today.
Thank you. Thank you very much.
Well, everybody, as you can see, we all have some work to do before December 1st gets here. A big thank you to Ruth Dillingham for not only clarifying the rule, but helping us think through the ripple effects it will have on professionals all across the industry. If this episode raised new questions for you or sparked a conversation inside your office, we encourage you to revisit Ruth's informative article, which is linked in our show notes. We encourage you to share that information, that blog post, and this episode to everyone in your market who might be impacted, because a well-informed marketplace is going to be the best way to help reduce the chaos that lies ahead as this gets implemented. We will, of course, have ongoing coverage in the title report, the legal description, and our family of publications. So if you're not yet a subscriber, you can find a link to check them out in the show notes. But at a minimum, make sure you're signed up for our free e-news. That'll help you stay in the loop. We'll keep the coverage updated as this implementation and this go live evolves, and we'll have Ruth back again as we learn more answers to some of the questions. And as I mentioned, if you need a solid rock educator on this topic for your office or your customers or your marketplace or your association, feel free to reach out to Ruth. She's an amazing educator on this and all facets, really, of complying with issues related to residential real estate sales and mortgage lending, and I'll bet she'd be willing to help. So until next time, I'm Mary Schuster. Thanks for joining us. This has been Keys to Real Estate from October Research, where knowledge is the competitive advantage.